Hi everyone, I'm here with Jason Bogle of Stack QC and Bogle Law. Jason is specialized in criminal law, among other things.
Dressing appropriately for shooting video with Roxanne Soika.
Ensuring match.
Making sure the two of us match because of the fact that we are constantly in the courts and we've decided to do an informative video of how it is that the two worlds of criminal law and family law intercede with each other.
Absolutely, absolutely. So one of the reasons why we wanted to make this video was because most family lawyers do not understand how important it is to have knowledge of criminal law as well. And that's for a lot of things, including making sure that clients that are involved in domestic assault cases are aware of their rights and impact on their family cases. So for that reason, Jason is going to explain to us a little bit about what happens when someone is charged with domestic assault. First of all, what is domestic assault?
Now, of course, under the criminal code, domestic assault is a category of assault that deals with the relationship between someone that actually cohabitates or they are in some sort of a relationship with the other partner. Mm-hmm. And in domestic assaults, there are usually in every courthouse inside of Ontario a specialized team in the Crown's office that are focused primarily on domestic disputes. And in those type of situations, the courts are usually focused on the issues of making sure that the person who was assaulted is protected moving forward. And so a lot of the times when you have family court matters, you have situations where someone's bail or someone's sentence can affect their family court issues. So for instance, when a person is released on bail when they are alleged to have committed a domestic assault, you will find that there are usually boundary restrictions or a non-communication clause to ensure that there is going to be no other further issues occurring between the two parties. And in those instances, it's important to tell your family court lawyer, if you have a family court lawyer and not necessarily a criminal lawyer, what those conditions are, because they can affect your access and it can also affect your ability to communicate with your spouse or your children. Mm-hmm. And so those conditions are usually quite rigorous and they do take some time to amend if there are grounds to do so. But also in terms of sentencing, when a person is actually found guilty after trial, after being proved to have committed an actual assault on their partner or cohabitator, you find that the courts are very, very clear on trying to ensure or trying to assist in making sure that there's some sort of transition to deal with the fact that the person has now been convicted of the assault. And they're trying to address the fact that a family is a organic situation, and therefore the conditions that are imposed for the sentence and probation can also affect the access as well as the communications with the children or any other party that's involved in the family.
Absolutely. My experience, however, is that that particular piece regarding access and the family situation is not always taken into account. And that's in particular in the beginning. So when the police lay charges, and they discuss with the person that's being charged. They don't always get the right information, or they don't always put in the conditions, especially when there's an undertaking where just the police is involved and not a justice of the peace or a judge making the bail conditions. My experience has been that not oftentimes the right conditions are not there. Mm-hmm. So for example, assume a couple is getting separated or they're still together, but one of them gets charged. Sometimes the conditions that are in place upon that charge, so immediately, do not include conditions or exceptions regarding the children, the parties of children, or personal belongings, or things like that. So it's very important to understand the family law consequences of these kinds of conditions. And the criminal lawyer and the family lawyer should be very involved in understanding the process, and one needs to be done from the get-go, from the beginning. So as soon as someone gets charges or gets conditions in place, there should be an understanding of what is the next step to ensure that the family is able to move forward, notwithstanding the conditions. So that's my experience regarding that.
Absolutely. And you know what? You're hitting the nail on the head, because when it comes to situations involving a criminal lawyer, 9 times out of 10, most criminal lawyers do not have the experience of dealing with the family law context.
And vice versa.
And vice versa. And so it's important to make sure that when you're sitting down, you're talking with your lawyer, it's not just an issue of acquiring bail or just simply addressing the charges. It's also important for the criminal lawyer to communicate with the family lawyer and see what are the either existing orders that are in place for the family, and what, if anything, will these conditions upon a release will ultimately affect the family moving forward. And so once again, when you have a domestic situation, you'll see the intersection of both criminal and family law in these type of contexts. So it's always good to make sure that all parties understand what the courts have imposed in each one of those different courts.
And one thing that I very much like and I encourage people to do is, if they think they're going to get there, or if they think they have conflict with their partner, to always try to obtain legal advice in the criminal realm and in the family law realm. So how would that situation impact if you were to be charged, or if you have conflict? What's the process? So I always encourage people to obtain information and educate themselves. Why do I say that? I will give a typical example. What typically happens when someone is charged with domestic assault? As soon as a client is charged with assault, let's say they reside together with their spouse and their family, that client is no longer able to come back to the house. I have yet to see a case where they are charged, and of course we have the presumption of innocence. Notwithstanding that, I have yet to see a case where a person is charged with domestic assault and they are allowed to stay in the house. I have yet to see that. I'm not sure from your experience, but I'm sure, given the fact that domestic assault is, the domestic piece of the assault is an aggravating factor in the criminal code, and the Crowns are very worried about this. The system is very worried about domestic assault, and which is very true, which is domestic violence is a very big piece, and it's important to address this as well. Given the fact that it's not taken lightly whatsoever, it's taken very seriously, it can still impact people that are not able to defend themselves, that find themselves in a family law situation a lot worse than it should. So people should understand that as soon as one person is charged, they cannot be back at the house. You cannot go to the house, whether you own it or not, whether your children are at the house or not, you cannot go back there. And what's the ultimate effect of this? The ultimate effect is that you're recreating the status quo, whether you were separated before and living in the same house, or whether the separation was caused by the domestic assault charge. You're just now changing the status quo, whereas the person that resides in the house, the complainant, now has almost the upper hand in the case, because now they have the advantage given the children reside with them and not with you. And status quo is everything in family law. And that is why it's very, very important to understand that and to obtain advice from the beginning.
Absolutely. And so when it comes to the criminal context, we understand that the police's job at the time when they receive information is to make sure that they separate the parties and ensure that the parties are separated to the point of when a resolution to the dispute in the criminal courts have been resolved, either by way of guilty plea or by way of trial. And given the fact that we are in COVID-19 and that we are essentially operating on a video basis, that can last for a significantly long period of time. So when it comes to these type of conditions, they can be quite onerous on the family as well as on the individuals who are charged.
So I think stemming from what you just said, some people might have the question of, I look to reconcile with my partner, I feel bad for calling the police, I want to withdraw the charges, and from my experience as well, that happens quite a bit, right? So people will say, okay, what if that happens? We made a mistake, we want to go back, please rewind, let's go back to how things were before. What do you have to say about that, Jason? I think people are really interested to hear about that.
Unfortunately, once the cart has left the barn, you can't just roll it back. We have things in place here in Canada and in Ontario, specifically called Victim Witness Assistance Program, VWAP. And so that program is designed to speak to the complainants in regards to any type of issues that they may have after a person has been charged with a criminal offense in relation to their partner. However, please note that the case is no longer in the hands of the complainant once the call has been made. It's in the hands of the state. And so it's up to the Crown to decide whether or not there could be conditions to allow you to have communications again, or whether or not there should be an actual prosecution of the case moving forward. So although the two parties may wish to reconcile and may hope to resolve the matters amongst themselves, once the police get involved, it is clear that it is now a state issue. And so the state will objectively decide whether or not the matter is going to proceed to trial or if there's some sort of alternative resolution that can happen.
And just to add to that, it's not only when the police charges the accused, it's also when, I just want to clarify, it's also, let's say you're someone who calls the police, makes a complaint, but then while talking to the police, actually, I don't want to press charges. You say those words, but you said the facts, right? He hit me, or she slapped me, or this happened. So I think it's too late even at that point to do anything. As soon as you pick up the phone to call the police, I'm not sure about your experience, but I think their policy is, we have the fact, now we have to proceed with this, we have to lay the charge.
I think it's a fair statement to say that once the police have enough evidence to investigate a crime, that they are obliged to do so. It's under the Police Service Act as well. So.
And can you define evidence?
Yes.
In this case, because people think evidence means a video, someone saw this happen. What is evidence particularly? What are the kinds of facts that are taken into account for domestic charge?
The word of any complainant is considered evidence. Random utterances, telephone calls, text messages. It's a whole slew, even written notes that have been predated like months or years ago that formulate a context of an environment that is oppressive is still considered evidence. So there is a myriad of different options that a police officer can use to suggest that there is evidence of a crime to investigate. It is incumbent upon the police officer to investigate a domestic assault, mainly because of the fact that it's the protection of the public, and because the public requires the assistance of the police to take allegations of assault, and specifically domestic assault, quite seriously because of the imbalance of trust and vulnerability of the relationship. That is why it is important for them to continue to investigate on any little piece of evidence. So.
Of course. So that's one question I think people would have, right? About, I want to go back, press the rewind button. Another question people might have is, I slapped him, she slapped me. What happens when both parties acted, inappropriately, and their actions would amount to domestic assault? What happens in those cases? Is the net effect zero, or how does the system react to this?
Well, it's not necessarily that the effect is zero. I think it's fair to say that the police have the option of charging both persons with assault. They can issue summons on all individuals to show up in triage court, or it's quite possible for the police to suggest that the parties need to be separated at the time and not lay charges at their general discretion, depending on it, the situation. Most times, if there is evidence of an assault, someone is being charged, and sometimes it could possibly be even both of them.
Absolutely. Very, very, very interesting topic. I think a lot of people are not aware of many of the things that we discussed. A lot of lawyers might not be aware of these things. A lot of criminal lawyers with regard to the family law side, and family lawyers with regard to the criminal law side. So it's a very interesting topic, and it's very, very important that everyone is informed, all the parties, all the lawyers.
So if you have any questions about family law, make sure you contact Skoika Law at the Berkeley Hub.
Or Mr. Jason Bogle of Sacusy and Bogle Law.
We're here at the Berkeley Hub.
Absolutely, always matching.
Always matching, doing our thing.
Bye, everyone.
Thank you.